and call the meeting to order. Chief of Staff, do we have a quorum?
Yes, Madam Chair. We have Commissioner Espinoza, Commissioner Byrd, and Chairperson Commissioner Vicente Aguilar with us. We also have General Counsel Mike Smith on the phone.
Okay, let's go ahead and get started with Pledge of Allegiance and the State Pledge. Hans Miller, can you please help us?
Yes, Madam Chair. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico, the Zia symbol of perfect friendship among united cultures.
Thank you very much. We go to the second item on the agenda, introduction of special guests.
Madam Chair, this is Jason. I know Jim Williamson wanted to introduce a new hire, but he probably is tied up working on the FY22 operating budget, so we may have to postpone that until next week. I don't see that he's here yet. That's all I have.
Okay. Okay. The next item on the agenda, consideration and approval of the agenda.
Madam Chair, this is Jeff.
Good morning, Commissioner Byrd.
Good morning. I would like to move discussion with commissioners to item number 6, which would be right after public comment, the first public comment.
I'll second that.
Is that a motion, Commissioner Byrd?
Yeah, so with that change, I'll move to accept the agenda with that change.
Second.
There's a motion to approve the agenda with changing communication with commissioners as item number 6. Seconded by Commissioner Espinoza. Michael Smith, roll call, please.
Commissioner Byrd. Aye. Commissioner Hall.
Aye.
Commissioner Espinoza.
Aye.
Commissioner Fishman.
Aye.
And Commissioner Vicente Aguilar.
Aye.
Madam Chair, Commissioners, the modified agenda is approved by a vote of 5-0.
The next item on the agenda is consideration and approval of prior meeting minutes, August the 5th, 2020.
I'll move the minutes as submitted.
I'll second.
Roll call, please.
Commissioner Byrd. Aye. Commissioner Hall.
Aye.
Commissioner Espinoza.
Aye.
Commissioner Fishman.
Aye.
Commissioner Vicente Aguilar.
Aye.
Madam Chair, Commissioners, the the minutes for August 5th, 2020 are approved by a vote of 5-0.
Thank you very much. Public comment.
Madam Chair, this is Jason. We don't have anybody signed up today.
Thank you very much. The next item was modified, and we go to communications with commissioners.
And Madam Chair, this is Jeff.
Commissioner Byrd.
Thank you. I would like to have some discussions, not today, but on Monday. So I would like to ask for a executive closed meeting on Monday to talk about potential legal matters in regard to the move of the PRC. And I make that a motion if I didn't make that clear.
I can second
Any
that
discussion?
for.
A second by Commissioner Espinoza. And Michael Smith, is this a special, is it going to be titled a special meeting, closed session, or emergency meeting?
Madam Chair, Commissioners, my understanding is that this is a request for a special meeting. Normally, this is a procedural matter. If all the commissioners are in agreement to schedule a special meeting, it doesn't necessarily require a vote. It's just an instruction to our office to do that.
Okay.
So any other questions, Michael Smith? Can you please post it on the website, the closed meeting on Monday?
Madam Chair, then.
Okay. Madam Chair?
Commissioner Fishman?
Yeah, actually, if what's going to be discussed is what I anticipate, I want to get on the record that I'm opposed. And the only way I can do that, I believe, if it's going to be a closed meeting, is if I object to doing the meeting now. So correct me if I'm wrong on that, Michael.
Madam Chair, Commissioners, that's correct with Commissioner Fishman. Actually, if there is opposition to having a special meeting scheduled, then I think it would be proper for the Commission to take a vote on it.
So there probably wouldn't have needed a second. Is that right? Is that what you're saying?
Correct. It does now.
I see. Or you can put it on the agenda for Wednesday as a normal action 2 days later.
Madam Chair, Commissioners, that's obviously the Commission's protocol is always that any commissioner can request something to be placed on a regularly scheduled open meeting. To call a special meeting, it doesn't require a vote if I have instructions from a majority of commissioners, but if it's being contested that we should have a meeting, then I think it's appropriate to have a vote on it.
Any other questions or comments? Roll call, please.
Madam Chair, yeah, okay. Yeah.
Commissioner Hall?
No, that's fine. We can just do the roll call.
Michael Smith?
Madam Chair,
if you
should I
can
take
please- Okay.
Madam Chair, Commissioners, just to clarify, this roll call vote would be to have a closed meeting to discuss potential litigation scheduled for Monday. We can talk about the time afterwards, but I'll take the roll then. Commissioner Byrd?
Aye. Michael, if we can please proceed. I'm sorry.
Madam Chair?
Proceed.
Commissioner Hall?
No.
Commissioner Espinoza? Commissioner Espinoza?
I'm here. I have terrible service. I guess, are we voting to put it on Monday or just the regular agenda on Wednesday?
This is a vote to put it on call a special meeting for Monday.
And I'm not sure what the subject is, but I'll support the, what was the subject?
I think if Commissioner Byrd wants to address that, since this is his motion.
Okay.
Get you unmuted there. Just to talk about potential legal issues regarding our move and funding. No, we haven't had a decision yet, but we need to talk about it as an organization, as a group.
I'll support that if that's what your wishes are. Yes.
Madam Chair, Commissioner, I just wanted to clarify with Commissioner Byrd. Commissioner Byrd, are you referring to litigation issues, or are you just referring to legal issues? Because a closed meeting can only be closed for litigation issues.
Well, potential litigation, yes.
Okay, I just wanted to clarify.
But we just need to have a discussion on it. Madam Chair,
think the
Commissioners, and I,
discussion should okay, but I think the discussion, the potential discussion should include all commissioners. Anyway,
right.
okay.
I mean, you can vote no, but that doesn't mean they can't join the meeting on Monday. That's fine.
No, I said I'll
Because not
support you.
I don't know that Commissioner Fishman will actually say no when we discuss the actual issue. He's concerned, and that's fine. And hopefully we can alleviate concerns when we're in a closed discussion with our attorneys.
Okay. So yeah, back to the meeting Monday. I'll support your effort, and so I vote yes.
Madam Chair, Commissioners, I will pick up the roll call then after Commissioner Espinoza. Commissioner Fishman.
I'm going to vote no, but yes, I will show up to the meeting if that's what the commission votes.
And Commissioner Vicente Aguilar.
Aye.
Madam Chair, Commissioners, I have a vote of 3 in favor, 2 against to hold the special meeting on Monday. So the next question then would be, in terms of scheduling that, what would be a preferred time to call that meeting?
Let's try.
No preference
10
on my part.
a.m.
Okay.
I'm sorry, Madam Chair, Commissioners, I didn't catch Commissioner Vicente Aguilar's statement.
10
Nor did I.
a.m. on Monday.
Madam Chair, Commissioner, again, sorry, everybody's talking over each other. I still didn't catch that.
Oh, can you provide the date for Monday and the time, 10 a.m. in the morning, a Zoom call, and ask the Chief of Staff to arrange it?
Madam Chair, yes, I can. So that would be Monday, August 31st.
24th, the 31st, yes. I can do that for you, Mike.
Any other communications with commissioners? If not, we go to the next item on the agenda, consent action items.
I move to approve. This is Commissioner Fishman.
Yes,
And
Commissioner
I'll
Fishman
second.
made a motion. Second by Commissioner Byrd. All those, if we can get a roll call from Michael Smith, and then also explain the consent action cases.
Madam Chair, Commissioners, this would be a vote on cases 20-00146 TRM in the matter of the application of the Village of San John, DBA San John Cooperative Ambulance Service. Is it Hone?
Oh,
Uh,
yeah, San Home.
It's always good to have some schooling. Let's see, where was I? Cooperative Ambulance Service for reissuance of certificate number 02690 to provide ambulance service. Case number 20-00147 TRM in the matter of the application of Fort Sumner Ambulance Service for reissuance of certificate number 22990 to provide ambulance service, and case number 20-00159 UT in the matter of a commission rulemaking to promulgate amendments to Rules 17.9.560.12.g, 17.10.650.11g, and 17.12.760.9 NMAC to prohibit discontinuation of residential utility service for the duration of the time that the governor's executive orders related to the COVID-19 pandemic are in effect. And that's a very short title. So I'll take the roll. Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
Commissioner Espinoza.
Aye.
Commissioner Fishman,
Aye.
and Commissioner Vicente Aguilar.
Aye.
Madam Chair, Commissioners, the consent action items are approved by a vote of 5-0.
Thank you. We go to the next item on the agenda, regular action items. The first case is 20-00126-UT. It's in the matter of the verified petition of Kit Carson Electric Co-op. Russell Fisk from the General Counsel's office will explain his order. Russell?
Good morning, Madam Chair, Commissioners. Can you hear me?
Yes,
Yes.
we can hear you.
Yes.
Okay. This comes before the Commission on Kit Carson Electric Cooperative's motion for rehearing regarding the Commission's August 5th, 2020 order. That order did a number of things, but one of the things that it did, which is the issue that Kit Carson asked to be reconsidered, is that the Commission granted a limited ETC designation to Kit Carson for the purpose of receiving funds from the broadband program, and the language to which Kit Carson objects, the limiting language that was in that order, is that the order limits that to Kit Carson's pending broadband program application in docket number 2099 UT. That's the broadband application docket. That's the specific part of the order to which Kit Carson objects. Kit Carson, in their motion for rehearing, states that in their verified petition, which started the case, they asked for designation as an ETC for the broadband program for 2020 and future years. In other words, it wouldn't only cover, the designation would not only cover this year's application, but any future applications. Kit Carson argues, among other things in their motion, that if the Commission were to limit its ETC designation to this year only, then Kit Carson would be put to great expense and delay by having to reapply for such designation for each year for which it sought broadband program funds. Kit Carson concludes that such a result would not serve the interests of administrative efficiency and conservation of Commission and party resources. I'm going to skip ahead because there are some other arguments that Kit Carson makes, but since I'm recommending that the Commission grant the motion, I'm just going to highlight the ones that I think are most important at this time, and I can go back and discuss others if you like. Let me get to staff's opposition. Now, as you will recall, there are two other parties to this case, staff and NMECG. NMECG is the New Mexico Exchange Carrier Group, which represents a number of the rural ILECs. NMECG stated that it does not oppose this motion. It does not oppose Kit Carson's request for a broader ETC designation that would include future applications. There's a lot of background noise, or is everybody hearing a lot of background noise?
Yeah.
Okay, well, it's okay.
I just thought it was coming from you.
No, it's not.
Russell,
It's not happening here.
Russell, let me just remind everyone that's listening on the phone, there is some background noises. It looks like somebody is shuffling papers or something like that. Please keep it quiet. Russell, go back to your presentation.
Thank you, Madam Chair. So as I said, NMECG does not oppose the motion for rehearing. Staff, however, does. On Monday, staff filed a response to the motion in which it states opposition to the motion on 3 grounds. First, staff states that the issue of continuing an ongoing ETC designation, in other words, for future years, was never addressed by staff or litigated in the hearing that resulted in the August 5th order. Second, staff references other pending petitions for ETC designation for broadband program funding, contending that although circumstances differ, other applicants may ask for equal treatment, especially in regard to ongoing ETC designation for future broadband applications, and voices a concern that considering such applications on the fly will result in granting petitions without sufficient evidence. Third, staff argues that there is absolutely no urgency or need for the commission to make this determination at this time. Now let me go on to my proposed order. The proposed order would agree with Kit Carson and find that administrative efficiency and conservation of resources would be served by granting an ETC designation of a more expansive scope with regard to Kit Carson's designation for broadband program purposes. The lack of opposition by other carriers, specifically NMECG, to the more expansive scope of designation is an important indicator in favor of granting this ETC designation. In other words, that other carriers are not objecting to a broader designation. One of the primary reasons why I drafted the August 5th order more narrowly to include only the pending application was that I was concerned that NMECG would be opposed to a broader scope, and they're not. You might recall that Bill Templeman, the attorney for NMECG, asked questions of Luis Reyes and Mike Ripperger with regard to future applications, but as it turns out, NMECG is not concerned about that issue, at least with regard to Kit Carson. They're not opposing. Also, it seemed to me when I drafted the order that Kit Carson was willing to accept a narrower scope in order to secure staff's non-opposition, but Kit Carson has reaffirmed that it would like the broader scope. So those are reasons why I would reconsider that language. With regard to staff's opposition, my proposed order would first note that it is indeed urgent for the commission to decide this issue now, specifically for the reason that it may impact other pending petitions regarding broadband program designation that are on an expedited schedule. This is not to say, and I'm reading the language of the order to make it clear, what this order would say. That's not to say that in every instance, ETC designation for broadband program purposes should be granted to the same extent as here. That must be decided on a case-by-case basis. However, it's noteworthy that with regard to the only other similar petition, in other words, the only other petition with regard to broadband program funding, ETC designation for that purpose that has been granted, that of Plateau Telecommunications, staff stipulated with the company, Plateau, to agree to the more expansive approach. Staff was willing to go along with an ETC designation that included future applications. So it's unclear why staff would oppose it here, and just the vague allusion that's made in the opposition by staff to a lack of substantial evidence doesn't do anything to clarify that. The proposed order would state that the commission agrees with staff that staff's lack of opposition to the verified petition was based upon an understanding that the ETC designation area would be limited to the pending application. However, the reason I don't think the commission should simply rest on that and deny the motion is that staff hasn't explained why that is important as a consideration for staff, if indeed it was, and why the commission should consider that important. I don't know why they should. So with that, I'll take any questions.
Madam Chair?
Thank you. Yes.
Thank you. Yes, thank you. Russell, I really appreciate your details here. I was going to ask the question about staff not explaining. I mean, the 3 occasions they're asking for, there's not an urgency. What is, and whose bright idea to single out Kit Carson was this on staff? I mean, who is the staffer that is opposing this? And the 3 reasons they've cited, they haven't explained anything about the urgency, the equal treatment on the fly. That's what we want to do. We want to treat everyone across the board fairly. So I'd like to know, Russell, who in staff is opposing this? Whose bright idea was it to single these people out? That's all I want to know. And then I want a better explanation from whomever it was about the reason and the explanation they are saying that there's no urgency or a need. There's always a need, especially now. And so, Russell, could you just let me know, because this is just really getting old when we're just trying to, rehash and just go over this over and over and beat these people. So please just let me know.
Commissioner, are you asking me to answer that question now or later?
Just wanting to know, I mean, who,
oh, yes,
who
of course. Okay.
Yes. Is against it.
Yeah, Commissioner, obviously, I'm not privy to communications between attorney, like legal division and staff, so I don't know. But this was filed by Joan Ellis, who's a member of legal division and generally represents telecom. There was no affidavit or any other members of staff who, any members of staff or any other members of legal division on it. It was just Joan.
I see. Okay, thank you. And so there's probably no explanation, as you mentioned, staff hasn't explained the urgency or anything. So I agree with you, and I would agree with you and Kit Carson and move your order.
I'll second
Yeah.
that, Madam Chair.
Good.
Commissioner Fishman?
She beat me to seconding.
Okay, so you were going to second. Okay, there was a motion by Commissioner Espinosa, second by Commissioner Hall. Any other comments or discussion? If not, Michael Smith, if you can please take the roll call.
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Commissioner Espinoza,
Aye. I see.
Commissioner Fishman,
Aye.
and Commissioner Vicente Aguilar.
Aye.
Madam Chair, Commissioners, the proposed order on case 20-00126 UT is approved by a vote of 5-0.
And we go to the next case on the agenda, 20-00170-UT. And I'll let Russell Fisk explain his amendments that's put on the agenda.
Thank you, Madam Chair, Commissioners. I would like to ask if the Commission would like to call all three of these matters that are closely related. That's the next two matters on the agenda, 7316 UT and 1668 UT. There are three orders here, one for each of these cases that are closely related, and I assume the Commission will want to discuss all three at once.
That's fine with me.
Yeah, Madam Chair, I agree. I think that makes sense.
Okay, Russell, if you can combine all three cases.
Okay, will do. Okay, so these are three orders that are proposed by Commissioner Fishman, and I think these orders are a very good idea as well. And with these three cases, the three proposed orders are, first of all, in case 2170 UT, which would be a new rulemaking matter to consider potential amendments to the Commission's rule concerning IOSPs. Now, those are institutional operator service providers. They serve correctional facilities and jails. That would be, the first order would be to an initial order opening the new rulemaking docket to consider amendments to the Commission's rule governing IOSPs. The second order would be in case number 7316 UT, which would be an order closing that docket. That docket was called an inquiry docket in the matter of a Commission inquiry into rates and charges of IOSPs, but there were actually some adjudications that were made in that docket and stipulations that were done in that docket. It is, I believe, the oldest open docket at the Commission, and it is, in my opinion and the opinion of Commissioner Fishman, time to close that docket. Then there's also for 1668 UT, which is an existing rulemaking docket, which is similar to the one that would be open in 2178. There would also be an order closing docket there. I also agree with Commissioner Fishman on that. That was open in 2016. The only thing that's in that docket is an old proposed rule. So I'll get to that. So let me get to these three orders and how they're related. The proposed orders would all have essentially the same findings, and then the order at the end would be in the old dockets to close them and the new docket to go forward with the workshop. So the proposed order would find that the Commission's IOSP rule, which is 171128 NMAC, should be reviewed for potential amendments. It was adopted in August 15th, 2013. And in both dockets 1668 and 7316, there are all kinds of indications by the participants, including staff, that this rule is probably outdated and we need some fresh information. This rule does have 15-cent per minute rate caps in the commissions applicable to IOSPs. And by the way, that's a good sign, because as I noted in the letter that would be attached from the FCC to NARUC in all of these, for all of these orders, and the rulemaking that the FCC has recently opened just in this month, a lot of states actually apparently don't have any rules at all, or very high rate caps that allow for egregiously high intrastate rates. The commission is ahead of the game in that you already have a rule that has decent rate caps in place. So I think we're ahead of a lot of other states. However, many provisions of the IOSP rule should be reviewed and potentially amended, because it's still based on stale information in terms of cost information from 2013. And there have been major changes in the law. The FCC order that started a new rulemaking in August recognized that the FCC has been overturned by the DC Circuit. That's the court of appeal to which the FCC's orders are appealed, finding that a lot of the special costs and charges that show up in a lot of IOSP contracts with prisons and jails, the FCC had been trying to regulate those and saying that they were essentially interstate, or they were inextricably intrastate and interstate. Because as you know, the FCC has jurisdiction over interstate charges. State commissions have jurisdiction over intrastate charges. Well, in many orders issued in 2015, 2016, the FCC tried to regulate those, and now the DC Circuit in 2017 said, no, those are for the states to regulate. So not only are there, possibly stale costs and old-fashioned types of technology that probably aren't even used anymore that are referenced in our in the rule, there's also been a change which probably enlarges the commission's jurisdiction over certain types of charges, and we should consider changes to the rule on that basis as well. So the proposed orders would find, one, that a new docket should be opened for the purpose of the rulemaking, and it would just ask staff to meet and confer, or well, to confer, not meet, obviously, in the COVID area, not meet, in the COVID era, not meet, with IOSPs, so that they could hold a workshop no later than mid-October. Telecom staff is very, very busy right now, and so I think they should have at least until mid-October to hold a workshop. And of course, any commissioners could participate in that. I will participate in that whenever it's scheduled. With regard to the other dockets, particularly the 7-316 docket, there was an RD, a recommended decision that was issued way back in 2010 or 2011. Most of that was actually adopted by the commission, and it did concern rates and charges of what's now Securus, what was then had a different name. And there were also stipulations entered into in that docket, even before that, with other IOSPs. I don't agree with doing this on a piecemeal basis. Plus, staff has opposed closing this docket on that basis, saying there are still issues to be decided. But I would say whatever is in those RDs that hasn't been decided, most of the first RD was actually adopted by the commission. Any other remaining issues in the amended RD that came out later is going to be based on stale cost information. There are numbers in those RDs. It's not just concepts. So stale information, and also, as Securus has argued, this requires a rulemaking. We first establish standards and look at costs across the board before trying to apply standards to particular IOSPs, because we need to know what's going on today with regard to all IOSPs. As I said, Commissioner Fishman's orders would open a new docket for the rulemaking to start a workshop process, and then close the two older dockets. And with that, I'll take any questions.
Thank you very much, Russell. Questions or comments regarding the three cases that he just described?
Madam Chair, I move the order. I think it sounds
Commissioner
like
Hall?
it's the only, yeah, I think it sounds like the correct way to go. I mean, it doesn't make any sense to keep cases open when, it's based on really old, stale information that we know is incorrect. So we should just, put those cases into the rulemaking and, make it a process that can address all the similarly situated other entities.
There's a
Madam
motion
Chair?
by Commissioner Hall,
Madam Chair, I
by
second that
Commissioner-
motion.
second by Commissioner Espinosa. Commissioner Fishman, you have a question?
Well, I just wanted to say, all we're really trying to do here is be sure that prisoners get fair phone rates, under fair terms. And we got a lot of old stuff that we just kind of need to clear out. And we've got some new authority based on recent court decisions to be sure that phone rates are fair. And so I think, while I brought this up to Russell really carried the ball, did a great job of looking at what we need to do to sort of clear the field and just go about this in a rational, efficient way. So thank you, Russell.
Madam Chair,
Madam Chair, I'm sorry, go ahead.
I just
Commissioner
wanted to,
Espinosa.
thank you, Madam Chair. Thank Commissioner Fishman for bringing that up. It's been on the radar for quite some time. I mean, they do overcharge they have immense charges to those folks out there. So thanks for bringing that up, and hopefully you'll ensure that that'll get done and the rates will be fair, because that comes at a big expense to the families that have to pick up the tab for those calls.
Yeah.
Madam
Thank
Chair?
you, Madam.
Madam Chair, this is Russell. Could I just have a clarification on Commissioner Hall's order or motion?
Yes, please.
Commissioner Hall referred to moving the order. I assume she's moving all three of the orders in each of the dockets. Is that correct, Commissioner Hall?
That's the way
Correct,
they were
that is
submitted.
correct.
Okay,
Yeah,
thanks.
I thought that's how we were talking about them, yeah.
Do you have additional
Uh,
comments, Commissioner Hall?
Yes, I did. I just wanted to echo what Commissioner Espinosa and Commissioner Fishman have said. I think it's disturbing how costly it is for inmates to just be able to make a call, and I'm really glad to see something like this being done. And certainly, if the SEC is carrying out a rulemaking, then this is a good opportunity to be doing our own. So, so that's all I wanted to say. I think it's an excellent thing to be doing, and I'm glad there's some movement at the federal level too to right what's probably wrongs. Definitely unfair situation, unfair treatment of inmates. So, I'm glad to be able to do it.
Thank you. Any other questions or comments? If not, Michael Smith, please take the roll call.
Madam Chair, this would be a vote on an initial order in case 20-00170 UT, a potential order closing docket in case 16-00068 UT, and a potential order closing docket in case 07-00316 UT. Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
Commissioner Espinosa.
Aye.
Commissioner Fishman.
Aye.
And Commissioner Vicente Aguilar.
Aye.
Madam Chair, each of the three orders is approved by a vote of 5-0.
Thank you. Next case on the list, 18-00383-UT, in the matter of the filing of vice notice number 69 by Socorro Electric Co-op. Judith Amer.
Yes. Good morning, Madam Chair, members of the Commission. This matter comes before you today upon the joint motion of interveners, the City of Socorro, New Mexico Institute of Mining and Technology, and the Utility Division staff of the New Mexico Public Regulation, who filed a joint motion pursuant to Section 62-12-1 of the Public Utility Act. They're requesting an order from the Commission directing the New Mexico Attorney General to commence a mandamus action in district court by filing a petition in the name of the state of New Mexico seeking to compel compliance with the PRC's September 11th, 2019 final order in the rate case of Socorro Electric Cooperative in case number 18-00383. The proposed order would deny the joint motion, but I'd like to go through the background just to refresh your memory of what's happened in this case so far, because it's been a long case. And as you will recollect, in October 11th of 2019, Socorro Electric Cooperative appealed the final order in the rate case to the New Mexico Supreme Court, and also filed a motion to stay at the same time here at the commission. On October 30th, 2019, the PRC denied SEC's motion to stay. In addition, SEC filed a motion to stay with the New Mexico Supreme Court. However, to date, the New Mexico Supreme Court has neither granted nor denied nor ruled in any manner on SEC's motion to stay. So the final order, in my opinion, in 18-00383 is in effect at this moment. Then on April 15th, 2020, in response to a joint motion to compel SEC's compliance with the final order, the commission did issue an order granting the motion to compel and assessing fines for non-compliance. And that April 15th order, I'll now refer to as the compliance order. And it directed SEC to comply with the final order, fined SEC $1,000 a day for 180 days of past non-compliance, and another $1,000 a day going forward, imposed the fines on the SEC trustees instead of the cooperative members. And it specifically granted SEC an additional 60 days and specified that if they did meet that extended deadline, no fines would be assessed. Subsequently, on May 8th and May 13th, respectively, SEC filed an emergency writ of mandamus and request for a stay of the compliance order, and also filed a second appeal of the compliance order. So right now, there's 3 different matters that have been filed with the Supreme Court. There's the first appeal of the final order in the rate case. There's an emergency writ of mandamus and request for stay of the compliance order. And then there's a second appeal of the compliance order. Similarly to what I said earlier, the Supreme Court has not ruled on the emergency writ of mandamus or a request for stay or the second appeal. Subsequent to that, the commission directed me as their lawyer in the Office of General Counsel to file a joint stipulated motion to remand the compliance order with the New Mexico Supreme Court so that SEC and the commission could negotiate a resolution of the underlying rate case. Similarly, the Supreme Court has not ruled on the joint stipulated motion to remand. So we haven't been remanded the compliance order yet. On August 5th, the joint motion that's the subject of this public meeting today was filed by the 3 parties that I mentioned, the city, tech, and staff. And they request this order directing the Attorney General to file a mandamus action, asking a court to direct SEC to comply. As grounds for their joint motion, they state that SEC's disregard of the final order continues unabated, I'm quoting, and no fines have been paid, close quote. They cite to the recent case of State ex rel. Egolf versus NMPRC in support of the use of section 6212-1 to be used as a way to get compliance with an NMPRC orders. On August 19th, 2020, response to the position motion and attached an affidavit of one of SEC's attorneys, Patricia Martin, who attested to discussions that occurred between the PRC Office of General Counsel and the attorneys for SEC that had resulted ultimately in the filing of the joint stipulated motion to remand the second appeal of the compliance order, which I have previously mentioned to you. SEC asserts that the Supreme Court has jurisdiction of both the first appeal of the final order and the second appeal of the compliance order. Therefore, the Attorney General is divested of jurisdiction, citing to State versus White for the proposition that appeal of a judgment of a district court divests the district court of jurisdiction. In addition, they distinguish the State versus Egolf case and state that case is not applicable here because that holding is limited to NMPRC orders that have not yet been appealed. And finally, they are not simply disregarding the final order, that at every step of the way, they have been exercising their legal rights of appeal of the final order in the rate case. The proposed order concurs with the affidavit of SEC's attorney, Ms. Martin, that the PRC has sought to negotiate a resolution of the final order and the compliance order, and has sought a remand of jurisdiction back from the Supreme Court to be able to negotiate with SEC and to potentially make revisions possibly to the compliance order. Therefore, the joint motion that has been filed by the city and tech and staff requests the commission to take a position that's not consistent with the position taken in the joint stipulated motion to remand. Therefore, the commission should deny the joint motion. And I stand for questions.
Madam
Thank you,
Chair, I would
Judy.
move that order. Madam Chair, I would move that order to deny. It's not consistent as she stated, and it's not the direction we were taking. So with that, I move that order to deny.
Is there a second?
I'll second.
Any questions, comments, discussion time? If not, there's a motion by Commissioner Espinosa, second by Commissioner Byrd. Michael Smith, roll call, please.
Commissioner Byrd,
Aye.
Commissioner Hall,
No, and I'd like to explain. When the commission discussed whether or not to remand, I was opposed to it. I believe that the the recommended decision was sound and based on evidence, and I believe our decision to remand and try to negotiate was not based on evidence. And I believe the aggrieved parties, deserve their relief, and so I support what they're trying to do, and unfortunately, it's inconsistent with some action we've taken, but I don't agree with that. I don't agree with that action, so I'm going to vote no.
Commissioner Espinoza,
Aye.
Commissioner Fishman,
No.
Commissioner Vicente Aguilar.
Aye.
Madam Chair, Commissioners, the order sorry, I've lost my agenda here. In case 18383 UT on the joint motion to direct the Attorney General to commence mandamus proceeding is denied by, or rather is entered by a vote of 3 to 2.
Thank you very much.
Madam
Michael?
Madam Chair.
Commissioner Espinosa?
Thank you. I know we've all already voted, and that's, but I still would like to reiterate that we have very limited authority over these co-ops, and so I just think that we're over exercising our authority, and we have very limited over the co-ops, just like we do over propane and certain things. So anyway, thank you, Madam Chair.
Thank you.
Madam
Next
Chair, this is
item
Jeff.
is Commissioner Byrd.
Thank you. I also wanted to point out that there was additional information that came to light that the hearing examiner admitted that probably or may have changed the recommended decision, and bringing it back for discussion could change the outcome of that recommended decision. And I also want to state that I really disagree with the $1,000 per day per board member, because that is an accumulated amount of money that the end of the day, the co-op would have to pay, because as board members, they are, just like we as commissioners, are under the whole umbrella. The proper place to place fines for not complying with our orders would have been with the man or the individual who is the executive director, general manager, whatever their title is, that takes the responsibility. They sign the bottom of the line of the contracts, and that is where the proper place for penalties should have been placed, not on every board member, because that, again, that's an accumulated value that will cost customers that much more money should we need to actually impose that fine. And so with that, thank you, Madam Chair.
Madam Chair.
Commissioner Byrd. Commissioner Fishman.
Yeah, I just want to point out that if the co-op is competently run, each of those commissioners should be insured, and that insurance might cover that fine, although maybe it wouldn't cover that fine, because this was a case of the board willfully ignoring a legal order of the commission. And, I understand Commissioner Espinosa's feeling that she had a change of heart and she felt the commission made a wrong decision, which is fine. But I just don't think we should ever be encouraging co-ops or any entity to ignore orders that have been put in place legally after a full legal process. So anyway, I guess we've all said our piece, so thank you.
Yeah, I've got a comment. I mean, those were harsh, orders for a small co-op to comply with. And, whether you believe or not that they're competent, I don't think that's for us to judge, but I think that the public is the one that elects these members. And so, those were some harsh marching orders for a small co-op. And I just think we have such limited regulatory authority over them. We can't just always be trying to, rule when it's member owned, because they're the ones at the end of the day that have to pick up the tab on any punishments that we provide. So anyhow, thank you, Madam Chair.
Thank you. Any other questions or comments? If not,
Madam Chair.
Yes,
Madam Chair.
Commissioner Hall.
Well, I guess I would comment that had we continued on with the path we were pursuing of enforcement, it's clear that the co-op would have appealed, because they are appealing, and that would have been a good posture for the case to be in order for the court to make a determination that's probably needed about the extent of our authority over co-ops under circumstances like this, when a very robust protest was filed, and as it stands now, if we move through a settlement, those protesters won't have had an opportunity to have full due process and the remedy they seek. So to me, it just seemed like that would have been a cleaner, better way to go. And then we'd know. Then we'd have some guidance from the court. But we may end up with some sort of decision of the court on that point, or may not, depending on which appeals they deal with first as opposed to second. So it's much more complicated now in any case. So it's unfortunate, but it is what it is. But that's all I have to say. Thanks.
Madam Chair,
Commissioner
if I may, one last quick comment. I view, and again, other commissioners disagree, but I view the process that we originally went through was a case where the co-op wanted to do something. Members did not like what the co-op board was going to do, and they petitioned the commission for redress. And there's a legal process for that. And we looked at it, and and a decision was made. I thought the hearing examiner did a good job with it. And so what I just want to point out is that this was a case where the board was going a direction that its members did not want to go, and they exercised their legal right to come to the commission. And I feel like the commission did the right thing. People can disagree. And so there's kind of a bigger issue here is, should the commission have the authority when members feel like their board is not serving their interests to become essentially an appeals court, if you will, for them to bring their issues? And I think it should. And I can understand if others think they shouldn't. But to me, that seems to be the core issue here. Thanks.
Thank you, Commissioner Fishman. I believe that concludes the discussion on case number 18-00383-UT. We go to the next item. It's a discussion item, case number 20-00099-UT. It's in the matter of applications for 2021 broadband program support from the State Rural Universal Service Fund. Russell Fisk is going to cover this, and as well as Eugene Evans.
Thank you, Madam Chair, Commissioners. I'm just going to go ahead and turn this over to Eugene, and I'll be available for any questions that you may have for me at any time.
Okay, thank you.
Thank you, Russell.
Eugene, are you on the phone?
Yes, I am. Thank you, Russell. Good morning, Madam Chair, Commissioners. For the record, my name is Eugene Evans. I'm the telecommunication engineer for the Utility Division Telecommunication Bureau.
Eugene, can you please turn up the volume? Or if you can have the microphone closer to where you are speaking from?
Okay, can you hear me now?
Yes, thank you.
Okay, not a problem. As I said, my name is Eugene Evans, and I'm the telecommunication engineer for the Utility Division Telecommunication Bureau. Now, I'm here this morning to deliver staff's report on the proceedings for filing and consideration of the applications for the 2020 broadband program support. Now, also, I need to say that a full package of information was sent to each commissioner on the complete information submitted by every applicant. And at the end of this presentation, I will stand for any questions from the commission. At this time, I would like to go into a little introduction, and that is according to the State Rural University Service Fund rule and Broadband Program 17.11.10.31G, subset 3, staff is required on or before September the 1st to make a presentation to the Commission with an analysis of the application for awards. Now, this presentation fulfills the staff's requirements under the provision of 17.11.10.31 NMAC. There are a total of 11 applicants with a combined total of 35 proposed projects. The total cost of these 35 proposed projects is estimated at $21,555,260.64. with a total amount of monies requested from the broadband program of $16,132,972.04. Now, the applicants combined will contribute matching funds in a total amount of $5,422,288.63. Now, on December the 7th, 2017, the Commission issued this final order in case number 17-00077-UT, which repealed and replaced the SRUSF rules with an amended version. Among the amendments to the SRUSF rules were amendments to the broadband program provisions under 17.11.10.31 NMAC. The amended SRUSF rule includes the following provisions. On or before May 1st of each year, the Commission shall open a proceeding and establish a 30-day window for filing applications for broadband program support for the following calendar year. Whereas the Commission staff or third-party contractors shall review all timely applications pursuant to 17.11.10.31G, subset 1, NMAC. For the purpose of administrating the broadband program, the Commission may find that a broadband program proposed project area is a rural area, notwithstanding the definition of rural area in subsection X of 17.11.10.7 NMAC, if it's determined that, the area, 1, otherwise has the characteristics of a rural area. 2, the area is unserved or underserved by broadband. And 3, the public interest requires that the area be classified as rural. Now, the Commission on May 1st, 2020, issued an order opening proceedings for filing and consideration of applications for 2020 broadband program support to all interested eligible telecommunication carriers, just ETCs, in the state of New Mexico. And on May 31st, 2020, we had Smith Bagley Incorporated, also does business as Cellular One of Northeast Arizona, We also have Quest Corporation, also does business as CenturyLink, QC. We also have Plateau Telecommunications, Inc., and Valor Telecommunication of Texas, LLC, also does business as Windstream Communications Southwest. Baca Valley Telephone Company / Sierra Communications. Continental Divide Electric Co-op, Kit Carson Electric Co-op, Inc., and Kit Carson Internet. NTUA Wireless LLC / Comnet Wireless LLC. Panasso Valley Telephone Cooperative, Dell Telephone Cooperative, Inc., and Roosevelt County Rural Telephone Cooperative, also Inc., respectively, have filed broadband fund applications to qualify for the 2020 broadband program grants. Now, staff review is that staff for the Commission's Telecommunication Bureau have reviewed all the parties' information regarding their broadband application for consideration for 2020 applicant broadband program support grants. Now, in this report, staff will briefly explain and discuss the contents of the various projects proposed in the following order, respectively. I will start off with Smith Bagley, then Valor Telecommunication of Windstream, CenturyLink, Plateau Telecommunications, Baca Valley Telephone Company, Continental Divide Electric Co-op, Kit Carson Electric Co-op, NTU Wireless LLC, Panasso Valley Telephone Co-op, Dell Telephone Co-op, and Roosevelt County Rural Telephone Cooperative, Inc. Now, the broadband fund application was structured to emphasize every applicant proposed project in its most relevant detail and have applicants submit these details together in the form of attachments. Attachment A, which I will read out my attachments. Attachment A is a list of all addresses, total population, resident business, and uncooperative areas affected and funds requested. Attachment B is the project budget. Attachment C is the network or system diagram and services. Attachment D is design plans and documentations. Attachment E is project plans, project implementations plans. Attachment F is operational plans, providers information as well. Attachment G is area maps and/or GIS shape files. Attachment H is letters of support. Attachment I is commitments from community anchor institutions or public safety network. And finally, attachment J is all additional documentation or information relevant to the project. Secondly, staff utilized the available resources in regards to the New Mexico Department of Information Technology Interactive Web Broadband Map and Earth Data Analysis Center, which is referred as EDAC, data respectively to assist with the verification process of the applicant's submitted propagation, geomaps, and cartographic boundary shapefiles. Third, staff maintain an open channel of communication with each applicant to ensure the accuracy of their submitted applications. And in addition, staff constructed a digital spreadsheet to help emphasize for the commission, and each and every one of you commissioners should have received this, various project proposals and site locations for each applicant. This includes an interactive cost estimate tab to further assist the commission during this process. Now, this process allows staff to evaluate adhering to the compliance criteria established in 17.11.10.31 NMAC, each proposal separately, and construct a comprehensive report on every proposed project submitted by all the applicants. After reviewing all the information submitted to staff, by the applicants, staff believes that the companies have satisfactorily answered all of staff inquiries, and all the project proposals submitted by the applicants are accepted for consideration to move forward through the selection process by the commission. And finally, This process allows staff to analyze each proposal separately and construct a comprehensive report on each of the applicant's proposed broadband projects that are eligible for the grant. It also allows staff to evaluate the application in compliance with the criteria outlined, as I said, in 17.11.10.31 NMAC. Now, at this time, I would like to speak about the applicants and their proposal. Smith Bagley Incorporated also does business as Cellular One of Northeast Arizona. Now, Smith Bagley Incorporated proposed 13 new projects that consist of 5 LTE carrier upgrades, 2 LTE overlays, 5 new tower builds, and 1 fiber optic build out that would be used to construct and place into service the infrastructure needed to provide cellular voice services, mobile 4G LTE broadband data services to a mixture of unserved, underserved, and unincorporated areas of McKinley, Sandoval, and San Juan and Ciudad counties, respectively. Smith Bagley Wireless Network transport both voice and data transfer from each cell site or cellular tower back to a mobile switching center, or MSC. The MSC house core components to process voice calls, text messages, SMS, or multimedia service, which is pictures, stuff of that nature, messaging and data. Now, voice and text 3G technology that originate and terminate to users within the Smith Bagley network are routed and connected with the MSC. Voice and text originating and terminating outside of Smith Bagley network are routed by the MSC to the interface with the public switch telephone network. In this project, the existing 3G technology will continue to provide voice and text. Data sessions or requests, 3G and 4G LTE technology, are transported from the cell sites through the MSC to the internet and back to the users. In addition to the cellular voice services, to improve public safety and emergency service, mobile broadband 4G LTE, increasing the mobile data broadband speeds to 25 megabits per second down and 3 megabits per second up. Now, the total proposed cost for the 13 new projects is $7,728,583. The amount of the grant requested is $5,990,562. And the amount of the matching funds that Smith Bagley is putting in, which is 25%, is $22,066,645. The next applicant is Valor Telecommunication of Texas, LLC, also does business as Windstream Communications Southwest. Now, Windstream proposed 2 projects that would expand its delivery of wireline project service to the Tierra Amarilla and Berardi, unserved or underserved exchange areas. The proposed project will support broadband internet access services or speeds of at least 10 megabits per second down and 1 megabit per second up, and voice grade telephony services to all households and businesses in the proposed project area. Now, an Ethernet over fiber connected VDSL2 capable DSLAM, Windstream will utilize for some exchange a Radwin PDMP, which is a point to multipoint fixed wireless product. Now, the Radwin system will consist of a sector that will include a Radwin Jet Pro PTMP high capacity base station. Now, mind you, commissioners, I do have a glossary and a definition page within your packets for a lot of these acronyms to give some explanation as well. So please cruise that when you can. Guess what we have, and at least one or multiple Radwin 5000 subscriber units device operating in an unlicensed 5 gigahertz frequency band. Now, this has a radius coverage of 3 to 5 miles. The fixed wireless product will allow subscribers within the wireless coverage area to receive up to 100 megabits down and 10 megabits up internet speed. Now, the total proposed cost for the 4 projects is 2 projects, I'm sorry, which is $24,115. The amount for the grant fund requested is $18,086. And the amount for the matching funds that Windstream will place in 25% is $6,029. My next applicant is CenturyLink. Now, CenturyLink proposed 7 projects that would expand its infrastructure deployment of voice and broadband service to unserved and/or underserved rural areas of the Aztec, Maine, Santa Teresa, and Tucumcari exchanges. The underlying network architect are Central Office Direct Fed and copper T1/inverse multiplexer over ATM, Fed remote terminal DSLAMs, which is limited to 1 megabits per second, upgrade to a fiber to the network VDSL2 support pair bonding service of up to 100 megabits per second over existing copper access line. Now, each remote terminal DSLAM will have a 1 gigabit fiber trunk back to the central office where it will terminate on a Metro Optical Ethernet or MO network or a data agitation switch. Now, all enabled sites are proactively monitored for both port and bandwidth utilization. Any site reaching the predetermined threshold is triggered for examination to perform appropriate equipment augmentation to accommodate growth. Now, the total proposed cost for the 7 projects of CenturyLink is $1,108,131. Now, the amount of grant fund requested by CenturyLink is $831,098. The amount of the matching fund that CenturyLink will put in is $277,033. My next applicant is Plateau Telecommunication. Plateau proposed 3 projects that would provide access to voice and broadband services to customers that are currently unserved or underserved in the service territories of East Clovis Trail, Edgewood 2020 Trail, and the Indian Hill Trail service areas. Now, the 2020-21 Fiber of Premises project includes building 2 areas in Estancia Valley and 1 area in the rural stretch east of Clovis. Residents of these service areas live where the density is not sufficient to encourage competition. The Estancia Valley has tremendous potential growth due to the proximity to Albuquerque and the quality of life offered in a more rural environment. Now, the Clovis service areas is between spaces that have access to gigabit broadband services from Plateau. Plateau has built fiber to the urban area within Clovis, which has sufficient density to financially justify the construction of a fiber to the premise network. Now, NMR Telephone Co-op is the parent company of Plateau Telecommunication, has built fiber to their incumbent local exchange customers surrounding the proposed service areas of East Clovis. Therefore, these customers are in this often described donut between areas that have access to fiber to the premise-based broadband services. The access network will be a fiber to the premise network using standard active Ethernet technology with a dedicated fiber optic network terminal to each customer's home. Spare fiber optic strands will also be designed to accommodate growth in the area. The network will use an advanced dense wavelength division multiplexing, or DWDM, and multi-protocol labeling switching. Now, transport network to provide bandwidth on the core network. The network will provide 2 broadband data rates, 100 megabits per second symmetrical and 1 gigabit per second symmetrical. Now, the total proposed cost for these 3 projects is $2,160,574. The amount of the grant fund requested is $1,620,429. And the amount of the matching fund of the 25% is $540,145. My next applicant is Baca Valley Telephone Company / Sierra Communications. And Baca Valley proposed 4 projects that would provide access to voice and broadband service to customers that are currently unserved or underserved in its service territories. Baca Valley crew will install buried 48 fiber optic cables and offer broadband service to approximately 37 Raton residents in an area where only reliable service is via Sierra Wireless Internet. In addition to the fiber cable, we will also install the Calix 711 ONT and offer customers our Calix router. Now, the optical network terminals, which is ONTs, have 2 dial tone ports and 2 Ethernet ports. Mainline cables will be installed in a 1 1/4 interduct, and a drop will be bored and installed in a 3/4 interduct. They have also standardized on installing on their Calix 711 ONTs at customer homes or small businesses. Now, these ONTs are easy to install, are very reliable, and have 2 Ethernet and 2 dial tone ports. Should any customer need more ports, they have various upgrades to the ONTs to meet everyone's needs. Now, this project will not only have any direct middle mile components. The middle aspect is already in place and consists of a Calix and fiber optic cable to carry customers' traffic back to their Raton central office hub. Now, the total proposed cost for the 4 projects of Baca Valley is $398,382.34. The amount of the grant requested is $298,786.76, and the amount of their matching is $99,595.58. My next applicant is Continental Divide Electric Co-op. They propose a Zuni fiber project that is to be extend the Continental Divide Electric Co-op fiber backbone and fiber to the home network to the Zuni service area by constructing last mile fiber from the backbone built to serve the Zuni Public School District. Now, the Zuni service area is a 7.47 square mile corridor along New Mexico Highway 53 from west of Zuni Pueblo to Black Rock. The Continental Divide proposed a gigabit passive optical network, which is a GPON, GPON, fiber to the home network. Now, the fiber optic backhaul link will be configured using 10 gigabits per second of internet protocol. And this phase is part of a larger 4-phase approach to building a fiber ring connecting all of Continental Divide substations in New Mexico. Now, Continental Divide will be offering voice over IP service to residential and commercial accounts, along with broadband starting at 25 down and 25 up megabits per second, and also 1 gigabit and up, and also 1 gigabit down per second. Now, the total proposed cost for the Zuni fiber project is $4,313,644. The amount of the grant requested is $3,235,233. And the amount of the matching fund of their 25% is $99,595.58. My next applicant is Kit Carson Electric and Internet Co-op, Inc. The proposed projects are to construct the last mile fiber drop and the provision of routers of each home. The target member of those members who currently do not connect to a high-speed broadband network are low and moderate members, students, and members of the Taos and Pierce Pueblos. The network is scalable to increase both the number of member subscribers as well as the ability to increase its capacity beyond its original core design. The core can handle up to multiple 100 gigabits links with the scalability to offer from 25 megabits up and 1 gigabit to 1 gigabit. Now, what is the capacity of each link? The link east is multiple 10 gigabits links. The north link is 10 gigabits, scalable up to 40 gigabits link. And the link to the south is a 10 gigabit link. Kit Carson is in the process over the next 6 months to upgrade this 100 gigabits connection. The total proposed cost for the tiles and procures project is $846,250. The amount of the matching grant funds, I should say the amount of the funds that they request from the commission is $634,687.50, and the amount of the matching is $211,562.50. At this time, I would like to put an asterisk on Kit Carson, but I will discuss that at the end of my presentation. My next applicant is NTUA Wireless, LLC, ComNet Wireless, LLC. The proposed project in a rural, geographic, isolated, and sparsely populated area on the Navajo Nation, given the low density and remoteness of the area of Tahachi chapter, remains unserved in many parts and underserved in most areas. NTUAW is proposing to provide both mobile wireless broadband services and fixed wireless broadband services. NTUAW proposed that wireless technology would be the most efficient technology for this given area of low density and geographic isolation of the area. Now, NTUA proposed to provide last mile voice and broadband service utilizing 3G, 4G, cellular technology, and wireless internet service provider technology. Now, NTUAW will provide voice service utilizing a universal mobile telecommunication service, or UMTS technology, and the broadband service utilizing 4G, LTE, TDM radio access network, or RAN, and LTE, TDD, WISP service for end users, customers. NTUAW proposed to construct a 180-foot tower in Tahachi, New Mexico. The tower would deploy universal mobile telecommunication system and an LTE RAN time division multiplexer on the tower, and the Nokia equipment will be utilized. Now, the total proposed cost for the tiles and procures project is $772,676.30. The amount of the grant fund requested is $579,506, and the amount of the matching fund, 25%, is $193,168.82. My next applicant is Penasco Valley Telephone Co-op, Inc. The Picharo Road fiber to the premise project proposed an area located in an uncooperated area of the extreme southern Lincoln County and northern Chive County, Gaddis County. This project will provide fiber in the premise service to rural New Mexico residents who currently do not have any access to broadband internet. Now, the proposed project area is currently unserved by broadband standards. Throughout, PUT provides voice service to these locations. Now, completion of this fiber project will allow for voice and fiber to the premise broadband services of 25.3 megabits per second or greater to each location within the project area. Residents receive fast, high-speed broadband at an affordable price. Now, the total proposed cost for the Picharo Road fiber to the premise project is $1,600,652. The amount of the grant fund requested is $1,200,489, and the total amount of matching funds would be $400,163. My next applicant is Dell Telephone Co-op, Inc. The Tiburon Last Mile Upgrade and Expansion is their project, and it is designed to provide service to the town of Tiburon, New Mexico. Tiburon is located in Otero County in south central New Mexico. The town is located in a densely forested valley known as Sacramento Canyon on the southern slopes of the Sacramento Mountains. In the network core background will consist of a fiber optic cable from the Dale City Central Office and Tiburon Central Office, and is scalable to increase both the number of member subscribers. The core can handle multiple 10 gigabit links and divide among the various customers to offer symmetrical speeds of 25 megabits per second to 65 megabits per second, which can be upgraded to 100 gigabits per second. The proposed project seeks to provide 25 up, 25 down, or faster, megabits per second or faster last mile broadband internet services. Now, the total project proposed cost of Tiburon last mile upgrade and expansion is $748,000. The amount of the grant requested is $561,000, and the amount that they are going to match is $187,000. And lastly, Roosevelt County Rural Telephone Co-op. The Highway 202 project, they refer as their project, is proposed to design involve installing approximately 6.8 miles of aerial fiber and 17.4 miles of buried fiber to provide fiber to the premise broadband service to 20 locations. The applicant will utilize standard base active Ethernet fiber to the premise equipment to offer broadband speeds up to 100 megabits to the proposed 20 locations, but cannot receive 10 down, 10 and 1 megabits per second speeds today. It currently utilizes a 10 gig optical link that have sufficient capacity to backhaul services from an additional 20 customers' locations. Now, the proposed network involved the installation of fiber optic cable primarily along Highway 202 to the northeast of Portales, New Mexico. Approximately 6.8 miles of the installation will be aerial, with the remaining 17.4 miles being buried. Now, the fiber to the premise drops would be installed to the customer requesting service among the proposed routes. And the total proposed cost for the Highway 202 project is $1,555,250. The amount of the grant fund requested is $1,166,438. And the amount of the matching funds that Roosevelt County Rural Telephone would be $388,800. Now, as you
Thank you very much.
Madam Chair?
Yes.
Okay. That is the end of my presentation. However, I did want to address an asterisk. And that asterisk is that I had some late information coming in, and this is from Kit Carson concerning their application and information concerning some information that was from them that came in yesterday. And that was that they have, I have asked for a list of addresses that was required from my attachment A. And Kit Carson indicated that the 550 addresses are still pending due to, I quote, they're having a hard time narrowing down the list of 550 and identifying who needs service the most. So at this point, just to be fair with the applicants, that is still pending information that I'm still waiting on from Kit Carson. I do have a full list of roughly 4,120 that they have submitted, but it's not getting specific of the 550. So I'm still waiting on that information from Kit Carson. So that's still pending at this point. And with that, I am finished with my presentation. I'll stand for any questions.
Thank you very much, Eugene. Questions, comments from
Madam Chair?
commissioners?
Madam
Commissioner
Chair?
Hall?
Yes, I have a question for Eugene, and maybe it's not information that we ask the applicants to provide, but as I was listening to all this, I was wondering how many people are being reached, how many, users are being reached by each of these projects.
Yes.
I mean, it would be nice to know, and I was also curious about what distance is being covered. Not that it's necessarily relevant, but it's, I'm not sure unless I get some information. There was only one, the Roosevelt County one, I think, that mentioned what distance of buried fiber they were going to lay. And then the others didn't mention that. But in particular, I was really interested in, what sort of bang for the buck do these projects represent in terms of people being served? Do we have that information, or is that something we ask for? I mean, it seems like Kit Carson is struggling to provide that information, but I don't know why the others haven't provided it. Can you elaborate on that? Can you answer that?
I certainly can, Madam Chair. Commissioner Hall. As you should have known by now, I have submitted a short form presentation, which you just heard, and a long form presentation, which each commissioner should have received, that has a lot more information. And out of the aspect of time, I prefer to chose to just deliver the short presentation. The long presentation shows all the information that you requested, Commissioner Hall, and it indicated, as you say, the bang of the buck, and it's also the distance, and also most of the information that was submitted to the commission on these particular projects individually and efficiently on what they are going to provide. So I did put a short view, I should say, a lot more information on your long presentation, which you should have with you that you can, you can cruise through yourself. Also, you should have a flash drive which has all the information that was submitted to the commission by each applicant, and I'm speaking all of their information, that you can also go through as well. But for the time consideration of this presentation, I just submitted just a short presentation. I hope that suffices.
Madam Chair, Commissioners, this is Russell. May I also discuss this?
Yes.
Commissioner Hall, your remark, Commissioner Hall.
Well, I was going to make a remark, but I'd like to hear what Russell has to say. First, he might address my concerns in more detail. Yeah.
I'm sorry, Commissioner Hall. I just wanted to tell all the commissioners, I have all of that information. A couple of weeks ago, I sent you an email to you and your assistants, to all the commissioners and their assistants, with this short form presentation that you're looking at today, the long form presentation to which Eugene alluded, a spreadsheet that you can use to sort of to decide how to take out or find out what the cost impact would be to removing or adding projects. And then I do have those thumb drives, which is what Eugene mentioned, that have every single file, maps, etc., that supported the application. And I can provide those to you at any time. I haven't had any requests to send them yet, but I can send them. I have them here at my house. So just to let the commissioners know, I have all that information. And like I said, those four things: the short form, the long form, the spreadsheet, and also the glossary, the definitions to which Eugene alluded. Those I sent you in an email. I can resend all that today if you'd like.
Oh, Madam Chair.
Yes.
Well, thank you, Russell, for that. But what I, Madam Chair, would like to ask maybe would be whether or not Eugene could just generate a small table. It sounds wonderful that there's all this information, but I don't really, I would rather not have to plow through it to find this small piece of information that's probably at, the tip of his tongue or his fingertips anyhow, of Eugene, maybe just a table showing for each project how many people are being reached in comparison to the cost, and incidentally, well, not incidentally, what type of technology is it? Is it fiber? Is it wireless, fixed wireless? I mean, we have that information in this write-up, but really, I would just like to see the sort of bare bones information. You know, the technology, the cost, number of people being reached, and what distance they're covering. Would be really simple, and whether they're unserved or underserved areas or both, and what proportion of each. That's what I would like to know. And it could just be a table rather than a lot of extra text. To me, it's just an easier way to look at the relative merits of all the projects. And I also have a question, and this is maybe a question to Russell. Let's see, my understanding from previous discussions with Russell is that we won't be able to fund all of the projects that are being proposed from the broadband fund because of, because there's a much larger amount of projects being proposed this year compared to the previous 2 years. And we hadn't asked, when we presented this to the legislature, we hadn't anticipated, this increase, bidding because of COVID apparently. And so we didn't ask for an increase in the ceiling of the, of the $30 million ceiling of the fund. So is it correct still, Russell, that we won't be able to fund all these projects that are proposed and therefore have to pick and choose among them? Is that still the case or not?
Yes, Commissioner Hall, that's correct. And that was actually something I was going to address. Yes, the $30 million cap, that's a statutory cap on the overall size of the State Rural Universal Service Fund, is what will constrain us. As you know, the broadband program under the statute, that's the Rural Telecom Act, requires that we award at least $5 million, but there's no upper limit on that. The upper limit is on the size of the total fund. So I just, during this presentation, received from GVNW, our fund administrator, a preliminary calculation of how much money is needed for the other expenses of the fund or the other costs of the fund, most of which are the fixed payments to the rural ILECs, or not fixed, but the payments to the rural ILECs that are calculated under the statute. So they calculate what that would be, the non-broadband program items, and this is, again, a preliminary number, and I'm going to explain why there are things that could change. 18.8 million is about what the preliminary idea of what may be needed for the rest of the fund. So that leaves about $11.2 million for the commission to consider with regard to the broadband program. Now, as Eugene said, the total that's been requested in all the applications is 16.1 million, I believe. So the constraint will probably be around 11.2. Now, these are preliminary numbers. We're still receiving some information that we need to calculate this. I'm going to be talking to GVNW this afternoon. Also, as you know, there's a pending rulemaking regarding the SRUSF. In fact, there's a comment hearing next week. And there are a lot of proposed changes to the rule which could change, if adopted by the commission, could change the calculation of that $18.8 million, i.e. the non-broadband part. But assuming things are as they are now, no changes, then the commission probably has about $11.2 million. That's a preliminary number.
Well, Madam Chair, I'd like to ask another follow-on question.
Yes,
the rulemaking,
Commissioner Hall.
Thank you. The rulemaking you're referring to, Russell, in what direction might it move that 18.8 million, up or down?
It could move it down because some of the changes that are being suggested would, for instance, change the calculation of what the rural ILECs receive by including For instance, some have suggested, I believe NMACG suggested, including other types of lines in the access line calculation, which could increase the payments that are made to some of the rural ILECs. So that number would go up, and the number for broadband would go down. So it's a downward, it could be a downward adjustment to the amount that's available for the broadband program and an upward adjustment in those other payments. There are some other suggestions in there. There may be some other ones that go the other direction, but my recollection from reading the comments so far is that, you know, there are certain recommendations being made that would increase the size of the non-broadband program portion of the fund.
Madam Chair, if I might, I'd just like to ask one or two other questions. Let's see, Russell, has there been a determination made by staff, and maybe this is a staff question, whether or not all of these projects are satisfactory, and if we were to be able to fund them, we would? Or is that another step that we still have to take?
Well, I think you heard Eugene say that that the applications are complete, except he's waiting for some information from Kit Carson. The way that our rule is set up is if there are certain requirements for the application, and that's what the rule, that's what staff reviews in its presentations, that the applications include all that information, they make sense, and that they meet certain criteria like the 75-25, the issue of whether there's funding coming from other sources, federal funding, et cetera. Staff reviews for all that. Then, so my understanding is, and I could also bounce this back to Eugene, is that he's saying all the applications are complete, but he did mention about Kit Carson. He's waiting for some more information about that.
So, in other words, I guess I'm hearing you say if they're complete, including information about funding from elsewhere, then we provide a grant, the grant that they ask for, correct?
Well, this is what I would say to that. So it's not only the completeness of the application, but like I said, there are some minimum requirements. Then if all of these applications go forward to the commission and you have to deal with this limited amount of money, then there's only one criterion that's mentioned in our rule that the commission has to consider when prioritizing which to pay and which not to pay. And that is to prioritize unserved areas over underserved areas over served areas. So, and I think the commission sort of had that in mind anyway. Other than that, the commission can use other criteria, like you were mentioning, Commissioner Hall, like cost per person or something like that, to decide which ones to grant and which not to grant in order to stay within the $30 million cap.
Okay, and if we wanted to provide funding for all of these and didn't have enough money, are there any other options to pursue with respect to with respect to the $30 million fund? I mean, I think I'm hearing you say that there's a certain amount that is set in stone that has to be paid for other demands on the fund that are entitled to make demands on the fund. And then I guess we missed our opportunity to have the ceiling raised, but I guess maybe that's the only other option. Is that an option? Is that something we could ask the legislature to address this year or something? I mean, or is that too late for this round of projects?
That's an interesting question, because if the legislature changed this in the next session, it would probably become effective, the middle of next year, and the commission order would be this year, but the payments wouldn't start until next year. Very good question. I don't have a clear answer for you on that. I would think that the order that we issue this year would have to comply with the law as it is this year. One thing I would like to say in terms of if there are any potential adjustments that could reduce what the rural ILECs under the Access Reduction Support payments receive, there are some proposals in the Not all of the proposals that are in the State Rural Universal Service Fund rulemaking would increase those. There is a proposal, I don't know if y'all recall, but the commission has basically set in stone this last year an $18 affordability benchmark rate. And if that benchmark rate were raised, it could decrease the size of the payments that are made to the rural ILECs and create some more room in the fund, but they would probably also result in an increase in the rates that those rural ILECs charge. I don't feel like we should talk too much about this anymore because the rulemaking itself is not on the agenda for today. I would recommend that any commissioners who want to listen in on the hearing, comment hearing on September 2nd, that's next Wednesday in the rulemaking. But I do feel like we can discuss it to some extent because obviously the size of the fund impacts this issue. So, yes.
Okay, thank you very much. Thank you very much, Russell and Eugene and Madam Chair. I'm done with my questions.
Madam Chair?
Thank you very much.
Madam Chair?
Commissioner Fishman?
Madam Chair?
Commissioner, oh, Russell.
No, this is Eugene.
I'm sorry, that was Eugene.
Oh, it's Eugene. I'm sorry. Go ahead.
That's okay. Madam Chair, I just want, before we move to Commissioner Fishman, I wanted to address a question that Commissioner Hall put out there, and that is concerning the amount of information or in what she feels is a lack of information of my presentation this morning was designed to be that way, and that is a lack of for time consideration. Now, I strongly suggest for every commissioner to read over my long presentation, which you should have, and that presentation, information breaks down a lot further within the companies and what they're doing, what the locations is. Concerning all the questions that Commissioner Hall brought up when it comes down to individuals, comes down to how many populations, the money, the funds, and what they're doing technology-wise. And I tried my best to put it in the most general sense so it won't be so cumbersome for you to understand, along with our definition and glossary. So I strongly suggest that should be read when you're making up your decisions, so you have a lot more information that I did leave out purposely in your presentation. That's all I need.
Thank you, Eugene. Any other questions?
Madam Chair, this is Jeff.
Commissioner Byrd.
Thank you, Madam Chair. Good morning, Eugene.
Good morning, Commissioner.
Have you done the ranking? Even just the basic ranking that Mr. Fisk mentioned?
Ranking as in ranking of the projects, if that is what you refer to? No, that is not in my responsibilities, I guess, in some ways, because I am not going, I'm not here to put a thumb on the scale of who gets selected. I'm here to offer the information that was submitted, the technical analysis of what they were intent on doing and how much it's going to take and who's going to provide it. Now, I think it's not in my position to put a rank on it in a sense, and that's like helping you making selections in that manner. So no, I have not, sir.
How about you, Russell? Have you done it?
Commissioner Byrd, no, I have not. But I am more than willing to work with commissioners on the prioritization issue and helping sift through all this information. Like I said, the rule only provides that the commission, with regard to prioritization criteria, that you do prioritize unserved over underserved over served. So I could prepare a spreadsheet like that for you. Eugene is right. The staff is just supposed to review for completeness. Of course, if they have questions for the applicants about whether something makes sense, they need to understand it. They review for that. And also they review for the minimum requirements. The prioritization is all up to the commission and up to me to work with you on that. Now, again, I'd like to note we can continue to speak with Eugene and staff, because this is a case where staff is in the the position of advisory to the commission, so we can speak freely and get more information if we need it. Like I said, I have more information, but I can definitely work through the commission with any commissioner in the next month, or even more than the next month, if the commission wants to go beyond the October 1st date to help, to sift through this information and apply whatever criteria the commission is interested in applying, in addition to the criterion that's in the rule.
Madam Chair, Commissioner Byrd?
So I see,
I believe
Commissioner
This is-
Commissioner Byrd is still asking questions.
I was going to answer something for him. That's okay.
go ahead, Eugene.
What I was going to say to you is that when I went through each and every one of these applications, every application is a viable application and they serve worth. And the technology that they're using was to the limit of how things should be done, and also in the specifications and also the newness of it. So therefore, it passes that test as well. Now, the difference between the projects itself, the technologies, and the amount that it's going to take is various through each and every project, obviously. But I can say that every project has been vetted, and every project has a very valuable aspect on providing internet service.
Okay. Well, so what I realize now is that the term "the commission" is being used slightly differently than how we normally handle it on different cases. Usually the commission is referred to as staff presenting, and now the commission is actually us, the commissioners, which is fine. It's just a change in the definition of the term.
Well, I guess, Commissioner Byrd, I guess I don't understand. Staff's role under the rule is to review and then make this presentation, and then the commission makes all decisions, prioritizes based on, the commission does have a lot of leeway. At that point, you're right, it is different from other cases where staff might have additional recommendations as to which way the commission should go. No, at this point, it's completely in the hands of the commission, and I'm ready to help the commission make those decisions.
And Commissioner.
Okay, I'll give you for example, many times you'll see the commission finds and concludes, but we as commissioners are being presented that finding and conclusion. So the term, the commission, has changed positions, which is fine. I'm not saying, I just realize I'm not opposed to what you guys are saying. It's just the term, the commission, has been changed from the support of the staff to the staff. Here's all the information, and I'm fine with that. But that's why I was asking the question, who's done the ranking, which is fine. We can do it. We're certainly capable. But I was looking for that because usually it's presented when it's under that statement.
Commissioner Byrd, can I address that?
Commissioner.
Eugene, you can answer the question.
Yes, I would like to address that with Commissioner Byrd. As the regulations and rules and the statutes indicated, as Russell indicated, that our job here, staff, is specifically me, is to identify and also to give analysis of the actual project. However, that is not where my I guess my help stops. Now, I am actually available for each and every commissioner who have questions about the technology, have questions about something that may be a little, need more information upon. I am privy to all the information, and I'm available for any commissioner to wish to have a conversation with me about this, so they can make any informed decision as they move forward. It's not that that staff is dropping this in your lap and say, you go run. I'm just basically indicating this is the information, this has been vetted, this has been going through the analysis, and then staff is available for any consultation that you may need as you go through the process of making a decision on, collectively making the decision on how you want to proceed with this moving forward.
And Commissioner Byrd, I just have one thing to add. You are absolutely correct. This is Russell. You're absolutely correct that this is a little different from other types of proceedings. And I was actually involved in the rulemaking that led to this broadband program rule. It was discussed at the time that we might have staff make recommendations on the application, but the commission actually decided to use the word presentation and to have staff only do a review as to completeness and whether it met minimum requirements and not to make recommendations. The commission actually decided that. This was a previous commission when it adopted the rule.
Madam Chair, this is Commissioner Fishman.
Commissioner Fishman?
Yeah, wanted to make a suggestion. Is Commissioner Hall had made a suggestion of summarizing key data in a chart, and I was thinking that doing something like that would certainly be helpful for me. And I was wondering, Russell, if it would make sense for you to, between now and next week's meeting, poll the commissioners on if we were to do kind of a summary chart. What would you like to see in it that would help you make the decision? And that would serve two purposes. One, we would all know the criteria that's important to us, and we could see it in one place when we make the decision. And two, for transparency, the public would also have the benefit of the same thing being on the record. And it would give a chance for each commissioner to point out what was important to them, and it would be included on the chart. So everybody's criteria would be there. And so I'm wondering if the rest of the commission thinks that would be a good idea.
Madam Chair.
Well, we're still on Commissioner Fishman, and I would like Russell to respond. Commissioner Fishman asked the question, can you provide a summary chart?
Madam Chair, this is Russell. Yes, absolutely. I can work with Eugene on that, and I can send out an email to all the commissioners to ask them what information they'd like. I think that would be helpful, and then I can have it filed in the record of the case.
Okay. Commissioner Hall?
Yes, Madam Chair. I was just thinking, Commissioner Fishman wanted to hear responses from the commissioners right then, but I'm in favor of that. That is what I would like to, and I think it's great to have Russell poll other commissioners. And then I think it's also good because if we can establish some, criteria that we are all satisfied with, and that provides, guidance to staff. So, going forward, if they want to do that sort of analysis, then it's in black and white. And if they're, or if it's appropriate for a general counsel to do it, it doesn't matter to me who does it. But if we get the kind of information that we can get in, in some sort of uniform way, then that'll help us to do the ranking process. And that would be very helpful for us in our decision making.
Madam
So
Chair?
that's it.
Madam Chair, this is Eugene again.
Yes, Eugene.
I would like to at least indicate that all commissioners, you did receive a spreadsheet and a well put together spreadsheet that basically differentiate each and every applicant, each and every job process of it, what they design. I mean, is broken down in the most layman terms I can possibly do. And it's just a matter of actually looking at it and actually, and basically seeing exactly all the questions that I'm hearing right now has been given. And it's just a matter of actually going through the spreadsheet that I created, going through the definitions that I also created to help you guys to, each commissioners to make a decision. The information is there. It's not scattered. It's not cumbersome. It is there. It's just a matter of looking through the spreadsheet as well as the cost estimate tab that I made in order to make your decision. That's basically what I have to say.
Thank you. Any other
Well,
questions?
Madam Chair, that's good. That's good news. That's good to hear. And I'm going to fish around and look for that email and pull out that spreadsheet. That's good. Thank you.
Well, Eugene?
Yes, Commissioner.
Madam Chair? Yeah, could you resend that just in case I've lost track of it? And,
Good idea. Yeah.
you know, just to be sure that we have it. And then if there's still things that we want to, by the way, this is not in any way criticizing your work. This is just us trying to get the simplest, cleanest handle for our purposes. So please don't take it that way, because it's not intended that way. We're just trying to get to something that's easy for us to digest and decide from. And it actually may well be there. We may have missed it. So just resend that. And again, my suggestion would be is if we still have some updates that we want to do with it, you know, I would still suggest we take it back to Russell. So, you know, if we need some other formatting, we can, as a commission, every commissioner has what they need.
Commissioner Fishman, I had that information. I just re-forwarded it to all the commissioners.
Terrific.
Great.
Thank you.
Okay.
Madam
Any other
Chair.
questions? Commissioner
Madam
Hall?
Chair?
Or
No, this is
Commissioner
Commissioner
Espinosa?
Espinosa. Madam Chair, here's my thoughts. I mean, I'm very comfortable reaching out to staff well in advance in preparation for our meetings. And so I have no problem talking to whether it's the attorneys or Russell or, Eugene. So Eugene, you are correct. That information's already in our inbox. It's already prepared. And so we've spent a lot of time, with those questions. It could have been, should feel free, commissioners should feel free to reach out to you like some of us do and, be prepared in advance for this. And so, again, I'm very comfortable talking to you and calling you again and just, again, in preparation for these meetings. So that's my input. I think Eugene has done his work and it's all there. And so I look forward to continuing working with all of you there on finishing this up and prioritizing and designating. So anyhow, thank you, Madam Chair, and thank you, Eugene.
Do we have any other questions, comments?
Madam Chair, this is
Thank you
Jeff.
very much, Commissioner Byrd.
Sorry about that. Just real quick, did I hear you say early on, Eugene, that we should have a thumb drive?
Madam Chair, Commissioner Byrd, yes, I submitted 5 thumb drives for each commissioner, as well as one for Russell Fitz. So it is in his possession, which is available for any commissioners who basically want it and be able to get it. So yes, and also if I can address Commissioner Fishman, I didn't take any offense to this. I realized that there's a lot of information. I realized there was a lot of questions that may be posed by this particular presentation, considering it's the short version of it, and I do give consideration of the decisions that the commissioners have to make on this. I am always available, and the information that I placed in this packet of a thumb drive should be more than enough to help you make a decision. However, I'm still available. But Commissioner Byrd, yes, you should have a thumb drive.
Yes, and Commissioner Byrd, I actually have all the thumb drives. This is Russell, and I was waiting to hear from anyone who wanted me to send one, and just let me know where you want me to send it.
Didn't know you had them. I'll text you my address.
Okay.
Okay.
Yeah, I will too.
I believe-
I will too.
Okay, so Commissioner Byrd and Commissioner Hall would like a thumb drive. Any other questions? Thank you very much, Eugene and Russell, with your presentation of the application. We go to the next item on the agenda. This is Michael Ripperger and Russell Fisk. It's in reference to the FCC Office of Inspector General, State Public Utility Commission cooperation regarding the Lifeline program. Russell, I'm not sure who wants to go first.
Madam Chair, Commissioners, I'll just give a brief introduction. Madam Chair actually asked that this be placed on the agenda for discussion. I believe that all commissioners received a letter from the FCC either this week or last week, which is just a general letter that I think the FCC sent to the FCC's Office of the Inspector General, sent to, I think, all state commissions. Just thanking commissions in general for having cooperated with the FCC in the past with regard to detecting any fraud, waste, or abuse in the Lifeline program. The FCC and its subsidiary or associated company, the Universal Service Administrative Company, actually audit those programs to make sure, you know, there aren't people getting multiple discounts, et cetera. And sometimes state commissions have assisted or discovered fraud, waste, or abuse and then reported it to the FCC. I talked to Mike about that. He wasn't aware of any instances in the past in which the commission, this commission had. It's usually larger state commissions with bigger staffs that discover this sort of thing before the FCC. But of course, you know, we're willing to, you know, it's good to have a contact there. With that, I'll take any questions, or Mike, if Mike wants to add anything to that, I don't know.
Thank you. Michael Ripperger.
Madam Chair, Commissioners, I really don't have much to add besides that. We have the FCC, and this is the Inspector General, but the FCC has reached out with a Lifeline task force to all the staff members in the various states and held calls to discuss any waste, fraud, and abuse. We do have regular contacts with the Universal Service Administrative Company and with the Consumer Relations Division to help customers with Lifeline issues and Lifeline applications. We don't receive a lot of those here, and we haven't really seen, you know, individually patterns or any single issues of abuse that we reported to the FCC. But we are, you know, all the states are in contact with the FCC. There are calls and there are letters that are sent out on occasion because the FCC is concerned about that. The primary, I would say, vetting that happens here on a lot of that is during the ETC application process. But they will be reaching out in this regard, and maybe through other bureaus within the FCC to query the states about if they're detecting any waste, fraud, or abuse in the Lifeline program.
Okay. Thank you very much. Anything that you would like to add, Russell?
Madam Chair, no, that's it for me.
Okay. Questions from commissioners? If not, we go to the next item on the agenda, advice notices. Western Farmers Electric Co-op. Do we have utility division staff members available?
Yes, Madam Chair. We have John Reynolds that will present the first advice notice.
Okay.
Good morning.
John Reynolds.
Yes, good morning, Madam Chair, and good morning, Commissioners.
Good morning.
I will present the Western Farmers Advice Notice, and David Alt will follow me with a matter from Zia Natural Gas, another advice notice. In the case of Western Farmers on July 22nd submitted an advice notice for a community solar provider number 2. Just to give you a little context, so Western Farmers is a generation and transmission cooperative that provides wholesale power to 21 member distribution cooperatives. 4 of those cooperatives are located in eastern New Mexico. The The community solar program, so to speak, is one that's offered by Western Farmers to its member co-ops. And Western Farmers is 100% supplier to these member cooperatives, but they allow each member cooperative, if they choose to, have a developed community solar facility interconnect with their grid. However, Western Farmers, as a 100% provider, is actually the developer of the community solar facility, and in turn sells that energy to the distribution. What this rider does is add some language to the community solar program generally, and it provides for since each individual community solar facility is generally unique to the needs or the requests of the member distribution cooperative, it provides for the actual energy generated by the community solar facility to be transferred to the member distribution co-op at the costs that are incurred to generate that energy. So it's by design meant to keep each member distribution co-op responsible to pay for the cost of the facilities that is interconnected to their grid. So it, based on my review, it provides for a fair treatment of what the distribution co-ops want and transfers the costs related to the community solar facility to them, and avoids as much as possible any subsidization. So based on that, my review and my discussion with Western Farmers, I'm recommending that this not be suspended and be allowed to go into effect as requested by Western Farmers on September 1st. With that, I stand for any questions.
Thank you, John. Do we have questions for John?
No questions.
If not, we go to the next item, Via Natural Gas Company's advice notice number 62.
Madam Chair, if I may, David, if you could please press *6.
Yes, I've done that. And can everybody hear me?
Yes.
Yes.
Let me start out with good morning, Madam Chair and Commissioners. It's been a long morning. I'd like to just read the advice notice number 62 that I prepared. On July 30th, Via Natural Gas Company filed advice notice number 62, Energy Efficiency Rate Rider Reconciliation. The current energy efficiency rate is 0.00111 per MCF of gas sold. If this rate is not adjusted, the under-recovered amounts for plan year 2020 will be $171,000, increasing to $576,000 in 2021 if no changes are made. If the rates are adjusted as proposed, the residential rate will increase by 26 cents in Lee County, 26 cents in Doñana County, 30 cents in Lincoln County, and 39 cents in Colfax County. If the rates are adjusted as proposed, the small commercial rates will increase by 79% in Lee County, 88%, 0.79% in Lee County, 0.88% in Doñana, 0.84% in Lincoln County, and 0.88% in Colfax. All of those commercial rate increases are under 1% increase. If the rates are adjusted as proposed, the large commercial rate will increase by 95% in Lee County, 1.04% in Doñana, 1.01 in Lincoln County, and 0.99% in Colfax County. There are no carrying charges submitted with rate rider number 2. As part of its annual report, ZIA will continue to analyze over and under recovered balances and file reconciliations applications as needed. Included in advice notice number 62 is the fourth revised rate rider number 2, applicable to the 2020 plan year. It includes the 0.00506 cent per cubic square foot of gas energy efficiency rider requested currently to become effective in September 2020. This number is calculated by dividing the over recovered balance by the projected year sales volume. This requested approval is in the public interest, and staff recommends approval of ZIA natural gas filing for advice notice 62. Any questions?
Thank you very much. Do we have any questions regarding ZIA Natural Gas Company's advice notice?
No questions.
There's no questions. Thank you very much for
Thank you very
staff
much.
members from, yes. If we go to the next item, public comment.
Madam Chair, we still do not have anybody that has signed up for today.
Okay. Communications with General Counsel.
Madam Chair, I think,
Madam Chair, I believe Russell Fisk would like to address an issue.
Mike and Madam Chair.
Okay, Russell.
Hey, Madam Chair, this is Russell. I think you did skip over communication with Chief of Staff. Is that correct? I'm not sure.
Oh, yes, I did do that. I'm sorry. Item number 11, communications with Chief of Staff.
Thank you, Madam Chair. Thanks, Russell. I'll keep it brief, Madam Chair. I know it's been a long day. It's been a long week already. But there's really not anything more to update as far as the PRC move goes. I've been meeting and continue to meet with each division to talk about preparing for the September 11th deadline. And I think we are headed in the right direction for that portion and phase of the move. I am scheduled to present before the Board of Finance on an amended grant application to possibly accommodate a private lease as early as January, just expecting that we will continue to operate via teleworking due to the pandemic and stay-at-home orders through the remainder of the calendar year. And so that's to be determined on what the results of that are going to be. But I think it's just a follow-up discussion for the most part and open discussion to our amended application from our July meeting, which I updated the commissioners, I think, back then. So I think just general purposes, we ordered more boxes. We continue to pack files and folders and just keep moving forward, Madam Chair. I don't know if there's any specific questions from any of the commissioners. I think I've been trying to communicate with you individually on your needs and making sure that we're accommodating anything that you have from your office. And I think we're in good shape for that. So I just sent out a calendar invitation for Monday's meeting. So you should have all of the credentials and criteria to call in for that meeting on Monday that we scheduled earlier. And that's really all I have, Madam Chair. There's a lot going on, but that's the main points today.
Okay. Questions from commissioners? If not, we go to the next item, communications with General Counsel.
Madam Chair, this is Russell. As the commission is aware, CenturyLink is proposing legislation for this next legislative session, and they asked me if I would be involved. They also, in a discussion, they also asked Mike Ripperger and I believe Jason. As you know, I responded to CenturyLink and said, I have not been authorized by the commission to participate in any such discussion, so I haven't. I believe Mike is on the line, and I can refer this over to him. He did have a discussion, I believe, yesterday with CenturyLink. But I'd like to say a couple things about the legislation first, because I have reviewed it and I forwarded it to the commission. This is legislation that's proposed by CenturyLink to amend the New Mexico Telecommunications Act. As you recall, there was a CenturyLink bill, essentially what was called, in 2017 that was passed, probably amended. In 2017, that was essentially going in the direction of deregulation. This legislation would further deregulate, or essentially, like puts it, clarify that the commission should be moving in a deregulatory direction. This proposed legislation really is targeted at two cases that were decided by the commission, or one rulemaking and one case that were decided by the commission last year and this year. The first was the commission's adoption of quality of service rules that apply to CenturyLink as an ILEC that has over 50,000 lines. As you recall, CenturyLink hoped that those would be more deregulatory than they turned out to be. They were in some ways deregulatory, but they opposed certain parts of those rules, and they have appealed that. About 3 weeks ago, I believe, I sent the commissioners a copy of my answer brief. In the appeal, the commission is opposing the appeal and standing by those quality of service rules as being consistent with the law, and also consistent with evidence in the record showing that CenturyLink in those areas, certain rural areas, was not maintaining and repairing its wireline infrastructure, particularly in areas where it's not subject to competition. So this legislation is aimed at that. First of all, it would literally say in the legislation that the commission must lower the level of regulation on CenturyLink, or on large ILECs, which only include CenturyLink at this time, from the level it was in 2017 to a lower level, and also to make it equivalent to a rural ILEC level. Rural ILECs will actually come under another statute, the Rural Telecom Act. There's another decision of the commission that's essentially targeted in this legislation. That was case 18295, the effective competition case. In that case, CenturyLink had requested that the commission find that with regard to its residential retail service, regular basic local local exchange service for residential customers, that CenturyLink was subject to effective competition in every single wire center in the state, and therefore entitled to an even lower level of regulation under the New Mexico Telecom Act. So this legislation would also target that. The commission decided, following and adopting the recommended decision of the hearing examiner, that CenturyLink had failed to show that it was subject to effective competition in any wire center in the state. And so this legislation would also basically attack that by creating new definitions and new criteria to be used in the test for determining effective competition. And so that's essentially what's in the legislation. And I can turn it over to Mike, or I can answer any further questions, any questions from the commissioners, Madam Chair.
Thank you very much.
Madam
Russell, any questions? Yes, Commissioner Byrd.
This is Jeff. Thank you. Why do you have reservations about helping Russell?
No, Commissioner Byrd, I don't have any reservations. If the commission authorizes me today to be involved in this legislation, I will gladly do so. But I do need an authorization to do that.
Okay.
Madam Chair.
Commissioner Hall?
Well, I guess I have a question, and maybe it's sort of stimulated by Commissioner Byrd's question too. It seems that the proposed legislation would kind of undo what we've done in a couple of decisions. And so therefore, I could understand why Russell might feel uncomfortable if he's been asked to assist, presumably to get the legislation passed, but I'm not clear on what they were asking you. On the other hand, if they want to what they're asking Russell. But Russell, I guess I should ask you this question. What is your understanding of what they want from you? I mean, it seems like they want to pass the legislation, the commission to roll back some of the constraints placed upon them by the commission. So I'm not even sure why they're asking you
Exactly.
to help them in that mission. And I don't know. I mean, just having said that much, I don't know. I would not be comfortable with you doing that. And I think it puts you in an incredibly awkward position. So can you shed any more light on what their question was? Did they actually want you to criticize what they'd written, help make it better to pass, but still reach the same objective? What's going on? I can't understand why they would ask you.
Commissioner Hall, I think those are very good questions. I believe I forwarded to the commission the emails that I had received, either from Leo Baca or Tim Goodwin. There wasn't any detailed description of what they want, what kind of involvement they wanted, except to be involved in a discussion. So I would say, first of all, I will never get involved in any legislation unless I'm authorized by the commission. Being involved in legislation is not part of my job as a member of Office of General Counsel. That's generally a policy-making area, but I will be involved if the commission ever votes, to want me to do that in any instance. But I would also agree with you, Commissioner Hall. The second thing is that this is legislation that is clearly targeted at undoing 2 decisions that the commission has made.
Okay, well, thank you for that. And Madam Chair, I do not think we should authorize him to, I do not think we should authorize Russell to meet with CenturyLink on this issue.
I agree, Madam Chair.
Starters.
I think, yeah. Sorry, I didn't mean to interrupt, but I couldn't agree with you
No,
more.
that's fine.
That's not part of your job, is right, Russell. And furthermore, I mean, they've always tried to pull in our employees to help them craft laws that, we end up voting on anyhow. And quality of service is already at a wash. And so it's, I don't know what more they want to dereg, but yeah, I don't think our staff should be, they're not getting paid. They're getting paid by the state to work for the Public Regulation Commission, not for utility that it regulates. And I don't see why you should have to help them dereg. So thank you, Madam Chair. Thank you, Commissioner Hall. But I don't think either of our staff should be helping craft any kind of legislation that deregs or even ends up back on our lap at some point to vote on. And that's always been a bad idea, to endorse or not endorse. It's gotten us in trouble several times, and it's created a conflict across the street with the legislators. And I don't think we should allow our staff to be a part of this. So thank you, Madam Chair.
Agreed.
Thank you. Thank you.
Thank you. Thank you. Any other comments? Questions? Russell, please do not get involved in CenturyLink or any telecommunications company regarding legislations, nor should our staff get involved. That's my take on it. Any other questions? If not, I believe that ends our meeting today, and we will have a special meeting on Monday at 10 a.m. See the instructions from our chief of staff. Bye-bye.
Thank you, Madam Chair.
Thank you.